Hello everybody, I am Sana Pervez, your legal expert for Hitbullseye, and in today's video we shall be discussing demonetization in the light of the recent constitutional bench judgment Vivek Narayan Sharma versus Union of India. So let's get into the video. As you might know, first of all we need to discuss what is demonetization in the first place. Demonetization is essentially denouncing of currency which are held to be legal tenders by the central bank. So as we all know that notes or currency notes or coins etc., all of this, they derive their value from the fact that the central bank, that is the Reserve Bank of India in this regard, has announced or has taken the duty and stated that these notes are essentially legal tenders. So these notes are backed up by the promise of the RBI that these notes shall have some value or the other, or basically the value that is written on the front, on the face of the note. Right. So basically, what happened on the 8th of November 2016, there was a sudden announcement on it was all over the media, it was all over all the news channels, etc., that Prime Minister Narendra Modi announced that all the currency notes of 500 and 1000 denominations would cease to be legal tenders, and that is that they will have no value whatsoever after a certain date, which was 3 days later. And secondly, issuance of 500 and 2000, which were new notes, banknotes, in exchange for the demonetized banknotes. So the purpose or the reason that was given by Prime Minister Narendra Modi was basically that it was crucial that that basically shadow economy was to be brought out. There were a lot of like economy, black market notes, etc., which were circulating not in the white but in the black market, and this led to a lot of basically financing in terror financing, drug trafficking, etc., human trafficking, all of that, because essentially all these notes were unannounced, unaudited, and circulating without the notice of the government because they were not taxed and they were just circulating without any notice to any authorities, official authorities whatsoever. So now what happened, what was the result of this was, as a result of this, after some days, after some time, an ordinance was passed by the parliament, by the president, that was called the Specified Banknotes Cessation of Liabilities Ordinance of 2016. Subsequently, in pursuance to the same ordinance, an act was passed of the same name, that is Specified Banknotes Cessation of Liabilities Act of 2017. This officially gave basically it officially gave some teeth to the notification that was given by the central government. Now when we say that the notification was given by the central government, we mean that it was given by the executive, and this act was the act of the legislature essentially. So as a result of the demonetization, first of all, 2,300 crore distinct notes were rendered futile, were rendered useless, and this amounted to a total of 15 lakh 44,000 crore rupees in real value if you calculate. Secondly, what were the effects of the demonetization? It, in the short term, immediately as the announcement was made on the news channels, it led to a great chaos. Firstly, what happened was that people started saving money, people started not spending because they did not know how the future was going to look. They started, so therefore, the manufacturing stopped all of a sudden. Then, in the agricultural sector, the farmers were reluctant to buy seeds to gain more produce. Their already made produce went, it perished essentially, and then unemployment rose to a great extent. People were laid off. People started saving. People did not know that whether the money that they had uh, amounted to anything or not. Then wages went unpaid for months at a strength. Then prices of agriculture, as we discussed, dropped in that very year. 1 to 2% of GDP, we saw a downfall of about 1 to 2% of GDP, which was a direct result of demonetization, apart from the downfall which we saw due to some other reasons as well. So, apart from all the other factors, it was challenged. There were a lot of petitions which immediately came before the various courts in the country, and it was challenged to be it was basically challenged to be against Article 300A, that is right to property, which is a constitutional right, firstly. Secondly, it was considered to be against the Article 14 and Article 19 and 21 of the Constitution. It was said to be discriminatory to NRIs because whereas there was no limit on exchange of banknotes from ATMs for the people who were residents of the country, there was, however, a limit on which was placed on the NRIs. So that is why it was the whole policy was petitioned against in number of courts, in a lot of high courts also, and in the Supreme Court also, and it was all clubbed together, and it was heard in one case of Vivek Narayan Sharma versus the Union of India, which we are discussing today. So first of all, we need to discuss what are the legal provisions that were brought about demonetization, or how essentially the demonetization came about. So first of all, RBI Act came into being in order to in order to establish RBI as the central body which is going to take care of the legal tender in the country. In section 26 of the Reserve Bank of India, legal tender character of the notes has been explained, and it is said that every banknote shall be legal tender at any place in India in payment or on any account of the government. Sorry. Yes, let's resume. Subject to the Subject to the provisions of the subsection 2, every banknote shall be legal tender at the place in India in payment or on account for amount expressed therein, and shall be guaranteed by the central government. That is essentially stating that legal currency is backed by the central government itself. Now, in the second clause, which is the most crucial, on recommendation of the central board of the central government may, on recommendation of the central board, we are talking about the central board of the RBI. The central government may, by notification in the official gazette of India, declare that with effect from such date as may be announced again by the central government of India, any series of bank notes of any denomination shall cease to be legal tenders save at such office or agency of the bank and to such extent as may be specified in the notification. So essentially it is stating that it is the prerogative or the power of the central government that after taking recommendation of the central board of the RBI, it can denounce any series. What has to be understood or what has to be taken care of is that it says that it can denounce any series of bank notes. So the first question which came into the case with regard to this was, when they're talking about any series, does that mean all the notes of that series or some notes of that series? So that was the first question. So the issues, essentially, there were 6 issues that were discussed. We've already discussed what the first issue was. It was with respect to section 2, subsection 2, section 26 of the Act. Second, interpretation of section this. If it means all, then is that excessive delegation of the power of legislature to the executive? Then thirdly, whether decision making process was flawed in this case. Fourthly, whether it passed the test of proportionality. Fifthly, period allowed for exchange was reasonable or not. Or and fourthly, can RBI accept notes beyond the time that was prescribed under the Act of 2017? Sorry. The constitutionality of this act was basically challenged, and it was taken up by the constitutional bench. The constitutional bench essentially was led by Justice S. Abdul Nazir, and it again comprised of Justice B.R. Gavai, A.S. Bopanna, Justice V. Ramasubramaniam, and Justice B.V. Nagaratna. What we have to remember in this particular case is that it is essentially a judgment of majority of 4 is to 1. So that means that Justice Abdul Nazir, B.R. Gavai, A.S. Bopanna, and V. Ramasubramaniam were in favor or held that the demonetization was constitutionally valid. However, there was a dissenting opinion by Justice B.V. Nagaratna, who is of the opinion that it was unlawful and therefore invalid. First issue, now let us discuss the first issue, whether the power available to the central government under subsection 2 of section 26 of RBI can be restricted to mean one or same series of banknotes and not all in the view of the word appearing before the word series. As we've already discussed, we discussed the phrase any series of banknotes. So does that mean all or only some? In this particular case, the Supreme Court perused the fact that in the previous two demonetizations that have taken place, one demonetization in India took place in 1946 and the other demonetization took place in 1978. In both the cases, there was a restrictive meaning that was given to the word any series, and which meant only some or one series of the banknotes and not the other notes in that very series. However, in this case, the Supreme Court constitutional bench had to say that only because earlier policies meant or restricted the powers does not mean that the powers will be restricted in the notification as well. That is why sorry, that is why the words anyone has been commonly used to mean everyone also, not one but all also. And in order to interpret this or in order to give a meaningful interpretation to the same, we have to give it a purposive interpretation. Purposive interpretation is the one in which the interpretation of statutes is done in such a way so as to, first of all, ascertain the intent of the legislature, and second of all, to make sure that the interpretation that the Supreme Court is making, it furthers that purpose essentially. And this particular interpretation of interpreting some as all was furthering the purpose of demonetization, and therefore this was opted for. The second issue was first issue being sorted, that is any series meaning all series. Does that mean it is excessive delegation of power from the legislature to the executive? As we sorry, as we already discussed, sorry, um, I'm sorry for my throat. As we already discussed, that growth of the legislative powers of the executive is a significant development of the 20th century. That is, earlier what used to happen was that the government or the parliament or the legislature was the main lawmaking body, and it used to make all the laws as detailed as possible. However, it is an invention, or it is more popular in the 20th century. What started to happen was that the government and the other agencies of the government also, they realized that it is practically not possible for the legislature to essentially dot all the i's and cross all the t's. So it cannot lay down an expansive legislation and it cannot lay down everything. So essentially what it does is, in this regard, it gives a guiding principle, certain guidelines in the act, and the guidelines have to be, they act as placeholders, and as placeholders have to be filled up by the executive. So if the central government is taking out certain notification, yes, we agree to the fact that the previous two demonetizations were done by the act of the parliament and not by the act of the executive, but that does not mean that executive should be curtailed in any power that was given to it by the legislature. So basically, delegated legislation was accepted in this regard, and it was stated that it is okay for the government, for the central government, to pass such a notification. Let us see what else the government had to, the constitutional bench had to say in this regard. In the present case, the delegation is to the central government, that is the highest executive body of the country. We have a parliamentary system in which the government is responsible to the parliament, in which the government is responsible to the parliament. In the case the executive does not act reasonably while exercising its power of delegated legislation, it is to be responsible to the parliament who is basically elected by the people. However, in this case, as we discussed, Justice B.V. Nagaratna dissented, stating that Parliament is nation in miniature and must be taken into confidence on basically such crucial issues. Next, let us discuss issue number 3. Issue number 3 is as to whether the impugned notification, that is the notification of 8th of November 2016, is liable to be struck down on the grounds of decision making processes flawed in law or not. So let us try to understand how the decision making process came into being in the first place. Under section 8 of the RBI Act, a central board of RBI is constituted, which prescribes or holds the directors of the RBI. Now, what happened on the 7th of November 2016 was that there was a meeting that was conducted by the central government, and the meeting, in the meeting, they came up with the discussions of demonetization, etc. The concerns of the meeting were forwarded to the RBI, and the RBI held a meeting within a span of 24 hours. That is, on the 8th of November, the RBI conducted a meeting on 5 p.m. And as soon as 8 p.m. on the 8th of November, on the very day, basically, Prime Minister Narendra Modi announced it to the public in media that demonetization is taking place from that very moment. So essentially, if we discuss that it was hardly like a 24-hour process, was it fair or was it not fair? So in this regard, the Supreme Court stated that in such matters, the scope of the Supreme Court is only to see whether or not there is any illegality in the procedure, and whether or not everybody who's involved in the procedure has applied its mind or not. It is not the job of the Supreme Court to see how much mind has been applied or has it been applied correctly or incorrectly in the opinion of the Supreme Court, but only if the procedure was basically followed or not. So, in the light of the fact that these policy matters require a large number of confidentiality that is to be maintained before such a decision is announced to public, that is why it had to be a short period of discussions, and that is why it was considered to be correct by 4 judges of the Supreme Court. However, dissenting from this opinion, Justice B.V. Nagaratna had to say that RBI didn't independently apply its mind in recommending demonetization. Entire exercise was held within 24 hours. So essentially, if the meeting of the RBI held at 5 p.m., so 5 p.m. to 8 p.m. was too short a time, and the RBI did not apply its mind independently in the opinion of Justice B.V. Nagaratna. In the next, issue 4, as to whether the impugned notification dated 8th of November is liable to be struck down applying the test of proportionality. When we discuss the test of proportionality, it is important for us to understand that any law has to commensurate with the objective with which it is introduced. So essentially, it is a four-pronged test which tests when some policies is going to be introduced, whether it is designated for a proper purpose. The purpose demonetization was to deal with or combat black currency. So that is a proper purpose. The measures undertaken to effectuate such limitation are rationally connected to fulfillment of that purpose. So in this case, what was held was that yes, if demonetization takes place, it is connected to black currency. Thirdly, the measures undertaken are necessary in that there are no alternative measures that may be similarly achieved that the same purpose with a lesser degree of limitation. So, while assessing this, the Supreme Court stated that it is very difficult to imagine what other alternatives could have been there in order to combat the black currency issue and terror financing, etc. This seems like first of all the in area of experts, and the Supreme Court could not come up with any such alternatives as such, and therefore it passed the third test as well. The fourth test is there needs to be a proper relation or proportionality stricto sensu between the importance of achieving the proper purpose and the social importance. This test also, according to the Supreme Court, the demonetization policy passed. Further on, the Supreme Court stated that fake currency, it is difficult to identify. It basically consists of unaccounted wealth. It is used for financing subserve activities, drug trafficking, terrorism, causing damage to security of the country, etc. So the damage that fake currency or the damage that illegal currency is doing to our country is basically massive, and therefore the test of proportionality in the light of these four circumstances was passed by the scheme of demonetization. The fifth issue was as to whether the period provided for exchange of the notes, that was a 52 days period, was provided to all the citizens so that they can go to the ATMs, to various ATMs, etc., and they can get their money and currency exchanged. Now, the issue was raised by the Supreme Court whether or not this period of 52 days was less. In this light, the Supreme Court found out that in a previous case, Jayantilal Ratanchand Shah, where the time limit was discussed, it was held that in the earlier two demonetizations, sorry, even a shorter time limit was given than 52 days. So the Supreme Court failed to see how 52 days would be a lesser uh, amount of time or unreasonable time in this regard. The sixth and the last issue was as to whether the RBI has independent powers under subsection 2 of section 4 of 2017 Act in isolation of the provisions of section 3 of the Act thereof to accept the demonetized notes beyond the specified period that was specified categorically under the 2017 Act, which followed the 2016 ordinance. In this particular case, basically under the Act of 2017, Section 3 declared that the specified banknotes will cease to be legal tenders from a certain date. Now, Section 4 worked out a mechanism in which certain grace period could be given to if the specified banknotes were deposited in a certain way to certain people only. So those certain people had the power to go on and accept notes that had already ceased to be legal tenders as per section 3 of the Act. In this regard, the Supreme Court stated that the RBI does not have independent power under subsection 2 of the Act. However, this power can be exercised if the central government delegates a power. So, this power can be exercised in consultation with the central government. In this regard, while the four judges of the Supreme Court had to say that in all the six issues, the scheme of demonetization passed all the tests, all the issues, and it was held that it was constitutionally valid. The Supreme Court majority of the judges basically stated that it might be a bad policy it might be a bad economic policy, but it is not for the judges to discuss what is good, what is not, what are the pros of a policy or what are not the pros of the policy. It is only for the Supreme Court. What it has to do is only to find out whether there was any illegality in the process or not, and the Supreme Court found out that there was no illegality per se in the process, and it also stated that meaning to say the Supreme Court, we are not experts in economic matters, and we cannot say that this policy is not as good and what could have been a better economic policy, and therefore demonetization was held constitutionally valid. However, in the dissenting opinion, B.V. Nagaratna Justice stated that demonetization was illegal, but no relief can be granted now, uh, because it is already been done and the consequences have already ensued. So this is all about the video. I hope you liked the video and you found the video informative. If you like the video, please do like.